Well, Doug and Nicole, just in the last hour, President Trump weighed in on the redistricting showdown, saying Texas House Democrats have abandoned the state. Democrats, though, have previously denied that claim.
The drama kicked into high gear the first week of August when Governor Greg Abbott asked the Supreme Court of Texas to do something unprecedented, declare the seat of House Democratic Caucus Chair Jean Wu vacant because Wu left the state with dozens of fellow Democrats to break quorum and stall a mid-decade congressional redistricting bill. The petition painted the walkout as abandonment of office. Within hours, Attorney General Ken Paxton piled on with his own filing urging the state's high court to expel a group of absent Democrats. Legal experts quickly called the theory a stretch. The Texas Constitution contemplates quorum breaks and sets out ways to compel members back, they noted, but doesn't equate a walkout with forfeiting your seat. The politics of the venue were hard to ignore. The Texas Supreme Court is entirely Republican, and its Chief Justice once served as Abbott's counsel. Still, the immediate question was narrower and more technical. Does a quorum break equal abandonment? And specialists said that argument pushes the premise to the breaking point. Before we start, smash the like and subscribe buttons for more updates. The redistricting that prompted the walkout roared forward anyway. On August 20th, after a 2-week delay caused by the Democrats' exodus, the Texas House approved a new congressional map designed, quite openly, to add up to 5 Republican seats in 2026. The Senate quickly took it up. By August 22, 23, the upper chamber had advanced and then passed the plan, and Abbott said he would sign it. Democrats denounced the map as a racially discriminatory power grab that bulldozed diverse urban districts around Austin, Dallas, Houston, and parts of South Texas, and they promised an immediate court fight. The timing matters here. It's mid-decade redistricting, only 4 years after Texas last drew lines following the 2020 census, and it came amid direct pressure from President Donald Trump to protect a slender U.S. House majority. To understand why the legal path ahead looks like a maze, you have to zoom out to the Supreme Court's rules of the road. In 2019, the justices held in Rucho v. Common Cause that partisan gerrymandering claims are political questions that federal courts won't referee. That shut the federal courthouse doors to challenges that maps are unfair because they help one party. But the court also left 2 crucial lanes open: racial gerrymandering claims under the Equal Protection Clause and vote dilution claims under Section 2 of the Voting Rights Act. In practice, that means Texas Democrats and allied groups can't sue in federal court simply because the map maximizes Republican performance, but they can argue it dilutes Black and Latino voting strength or uses race as the predominant factor while pretending it's all just politics. Even those lanes have narrowed. In May 2024, the court's conservative majority rejected a racial gerrymandering claim against South Carolina's map, emphasizing how high the evidentiary bar is to show race, not partisanship, predominated. That ruling will shape any Texas challenge that leans on similar theories. Democrats in Austin prepared for that reality. When they returned to the House floor after the walkout, they didn't just denounce the map, they peppered the bill sponsor with hours of questions aimed at building a factual record for court. They pressed on how race was considered, why public input was curtailed, and what the map would do to districts where communities of color have been the decisive coalition. The goal wasn't simply delay. It was to avoid a common litigation trap in which a state insists the map is purely partisan, then dares plaintiffs to prove otherwise. Expect to see those floor exchanges quoted in the first complaints filed in federal court. While the redistricting fight accelerates toward the federal courts, another front where Texas Democrats and the Supreme Court have been colliding is immigration, specifically Senate Bill 4, Texas's 2023 law that would have allowed state and local police to arrest migrants suspected of illegal entry and let state judges order them back across the border. In March 2024, the U.S. Supreme Court, over dissents, allowed SB 4 to briefly take effect while the appeals played out, triggering national headlines and frantic litigation steps. But the story didn't end there. On July 4, 2025, a divided panel of the Fifth Circuit held that SB 4 likely violates the Constitution because immigration enforcement is a federal domain, a principle the Supreme Court has recognized for roughly 150 years. The ruling reinstated the injunction blocking Texas from enforcing the law. In short, an early procedural win at the Supreme Court fizzled into a substantive loss on appeal, and unless reversed en banc or at the Supreme Court, SB 4 stays blocked. That immigration tug-of-war has a companion skirmish, the razor wire saga. In January 2024, the Supreme Court granted the Biden administration's request to let Border Patrol agents cut or move Texas's concertina wire along portions of the Rio Grande if needed for federal operations. The order was terse, but the bottom line was unmistakable. Federal agents must be able to do their jobs at the border, even if that conflicts with a state's enforcement posture. Texas kept pressing its broader border strategy and other foray, but the Supreme Court's emergency order underscored the constitutional tilt toward federal supremacy at the boundary line. Then there's the abortion battlefield, where the lines between Texas Democrats and the state's high courts, both state and federal, are stark. On May 31, 2024, the Texas Supreme Court unanimously rejected a high-profile challenge to the state's near-total abortion bans in Zorowski v. Texas, holding that existing medical emergency exceptions were sufficient and that doctors who had refused care were misreading the law. Patients and physicians told harrowing stories about delayed care for catastrophic pregnancies. The ruling left intact a regime that critics say will continue to chill doctors from intervening until a threat is dire. Paxton hailed the decision as a validation of the Human Life Protection Act, but medical and human rights groups warned that ambiguity would keep putting patients at risk. At the federal level, a different abortion fight just revved back up, and it could send the parties to Washington again. On August 22, 2025, Texas and Florida asked to join a still-pending challenge to the FDA's approval of mifepristone, the widely used abortion pill. The Supreme Court last year preserved access by ruling that the original anti-abortion doctor plaintiffs lacked standing, but it explicitly left the door open to other challengers. Texas's entry could cure the standing defect that had stalled the case, positioning the issue for another high-stakes Supreme Court confrontation. Strategically, Texas officials have also been sending cease-and-desist letters to pill providers and exploring novel legal theories to crack down on medication abortion that crosses state lines. For Texas Democrats, who have made defense of abortion access a core plank, this is the federal fight that most directly affects care inside their state, despite their minority status at the Capitol. If all that weren't enough, the mid-decade redistricting blitz is part of a broader national map war in which Texas is the lead domino. News outlets reported that Trump urged GOP-led legislatures to maximize partisan advantage now, not wait for the 2030 census, while Democrats in blue states prepared retaliatory redraws. Texas's bill sponsor said the quiet part aloud, the underlying goal was to improve Republican performance. Abbott has signaled he'll sign. Lawsuits are assured. That nationalization of map drawing ensures any Texas challenge will be watched as a test case for what's left of federal voting rights doctrine after the Supreme Court's recent decisions, and a bellwether for whether racial gerrymandering and Voting Rights Act claims can still rein in extreme maps. Legally, Texas Democrats have to thread a narrow needle. Because Rucho blocks pure partisanship claims in federal court, they must frame their case in terms of race. Either that the map intentionally dilutes the voting power of Black and Latino communities under Section 2, or that race predominated in the line drawing. But Alexander v. South Carolina NAACP shows how skeptical the current Supreme Court can be when plaintiffs argue that partisan targets are achieved through racial means. The court, in an opinion by Justice Alito, reversed a lower court finding that South Carolina used race as the predominant factor and instructed lower courts to avoid conflating the two. Texas Democrats will thus need detailed expert analysis and an extensive factual record to show that what looks like partisan hardball is in fact illegal race-based sorting or dilution. The state court angle adds a twist. After the House walkout, Abbott and Paxton went to the Texas Supreme Court, not just to win the redistricting policy, but to change the battlefield by sidelining Democratic leaders through quo warranto-style proceedings. That's a remarkable request in a separation of powers sense, asking judges to referee the ethics of legislative protest by declaring seats vacant. Analysts note the Texas Constitution has explicit tools for compelling attendance and punishing disorderly conduct. But abandonment is a different animal. If the court entertains the theory, it would set a hard-to-contain precedent, turning strategic absence into a justiciable offense. and inviting future governing majorities to use courts to kneecap legislative minorities. As of now, experts say the argument remains inconsistent with state law. Watch whether the court demands briefing on jurisdiction and proper plaintiffs before touching the merits. Meanwhile, on immigration, the Fifth Circuit's July 2025 decision blocking SB 4 reads like a civics lesson in federal supremacy. For nearly 150 years, the Supreme Court has recognized that entry, admission, and removal of non-citizens are exclusively federal functions. Texas argued its law complemented federal enforcement. The panel called it preempted. The ruling also rejected a procedural gambit after the federal government pared back its role in the case, holding that private plaintiffs had standing to challenge the law. That posture makes it more, not less likely that any eventual Supreme Court review will reach the core preemption question. For Texas Democrats, the bottom line is simple. The law they opposed never went into sustained effect, and the constitutional theory they favored has, so far, prevailed on appeal. If you liked this video, please give it a like and subscribe to our channel. Also, leave your comments below and tell us, what are your thoughts on Texas Democrats' clash with the Supreme Court? We want to hear from you. Thank you for watching, and see you next time.